Welcome back, everyone. It's the lawyer you know, and we've got a very special guest with us today. Nate, the lawyer, is coming on, and I was telling him beforehand that, I see a lot of lawyers on YouTube, and not all of them come off as nice, but that's a quality that he shows, at least in the videos that I've seen. He's thoughtful, he's nice, whether you agree with him or not, which is always a nice person to talk to. So I'm happy to have him on, Nate. Thanks for coming on, man.
Thanks for having me. This is I'm excited. This is exciting, especially talking to another former prosecutor. It's always great to have a conversation.
That's right. Prosecutor, criminal defense lawyer, and now mostly what I do is PI. But we have a lot of crossover in what
Nice.
we've done in our careers as lawyers, which I think is always important when we talk about cases that are in the news, like Kyle Rittenhouse, Ahmaud Arbery, and now the Reed case. And we can go in a lot of different directions because I haven't gotten your perspective on it, and a lot of people that follow my channel may not have seen yours, although he's got a huge channel. So I encourage you to check it out. And he hits all the cases that are going on. So most of you have probably already heard him. But I want to talk about specifically, instead of just diving into one case or the other, unless you want to, which is fine with me, what are some of the differences that you see from these three cases? Because to me, they all are very different.
You're talking about, all right, so I'm assuming we're talking Arbery, Rittenhouse, and Chaz, right? So the differences are,
well, when you say Chaz, are you talking about the Reed Caruth one?
The Reed case, the Reed Caruth. I'm sorry.
Yeah.
Chad.
Okay. No, you're good.
Chaz.
Yes. Okay. Yeah. Those are the three we're talking about.
The three, yeah. For all three cases have this self-defense element to it, but I think they're very different. And just the facts that are presented. One happened at someone's house. The other one happened in the middle of the road. The other one happened at a riot. Really not, people say it's a protest, but it's a protest riot. So they're all. It's interesting because they all have a lot of similarities, but I think legally they have some major differences. One is obviously a citizen's arrest case versus this one in Texas, which is just a straight, really a straight self-defense, right? I'm defending my home from someone. So it's legally, I think the questions are presented differently, but I think the outcomes, well, I'm thinking about it because the Arbery case really didn't hinge on the self-defense issue. It hinged on the citizen's arrest issue. So citizen's arrest was the main factor in the Arbery case, wherein I think self-defense in the Texas case and in the Rittenhouse case was the forefront. That's what we were talking about. So I think if we're talking about to distinguish those three cases, I think that's the way I would really distinguish them, where Arbery is really about citizen's arrest and these other two are really just straight self-defense cases. You know what I mean?
Yeah. So to me, one of the big differences is obviously the Reed case is the Castle Doctrine put to the test, basically. And we'll see if that is a difference between the Kyle Rittenhouse case, where right now no charges are filed against Reed. Kyle Rittenhouse obviously went the full bore before he was acquitted eventually. The Arbery case, which makes it interesting to me that people want to connect it to the Kyle Rittenhouse case, because in all three cases, which is interesting, some similarities, somebody reached for the gun of the person that ended up committing the murder, or the killing, whether it was justified or not justified.
Yeah.
So all three cases, we have a situation where they reached for the gun. But I think it's a different action that gets us there, legally speaking, to when you're reaching for the gun. Ahmaud Arbery at that point, in my opinion, had no choice but to try to defend himself. He's got pickup trucks blocking him in, one of which had already hit him. And now a guy's got a gun. What's he supposed to do? He is defending himself, in my opinion. That's different than what happened in the Kyle Rittenhouse case.
Yeah. Oh yeah, definitely. I think, well, and that's where it comes to, I think, what would they call the totality of the circumstances in the Arbery case? The totality of circumstances was they were committing a false imprisonment. I always analogize it to a robbery, right? You're committing a bank robbery. The person who's committing a bank robbery has no claim to self-defense, right? So if the clerk tries to grab for the gun, then there's no claim of self-defense. So that's kind of the Arbery situation, where I think when you're talking about the Rittenhouse situation, even though the first person did two people tried to grab for his gun, that was totally different because neither one of those people were justified in attacking Kyle Rittenhouse, where I think in the Arbery case, they were saying they were justified in attacking him through self-defense. So it's the cases all touch on self-defense, but I think the realities of it, each one of these cases are going to come down to different legal realities. Like you're saying, Castle Doctrine versus citizen's arrest versus just straight up self-defense for Kyle Rittenhouse.
Right, and that's I think the perfect microcosm of how to describe the differences in the three cases. What are your thoughts and feelings on the Reed case after watching the video? I'm sure you have. What's kind of your initial thought
Yes.
with the process?
Well, I watched the video, and I'm actually putting a video out today about it, and so I do PowerPoint, so everybody knows my little PowerPoint presentations, and what I like to do is I like to explain the law and let the jury or the fans become the jury. So I'll say, well, here's the law, and here are the facts, and now you apply the facts that we know to the law, and how do you come out? You know, if you come out for or against, it doesn't matter. It's just at least having a understanding on how to process this and come out to a conclusion just based on the evidence. With this case, it's interesting because I can see it coming out two ways. I can see it coming out where, number one, they were on the curtilage. And when you're talking about the curtilage, you're really talking about Fourth Amendment seizure stuff, right? You're talking about search and seizure because that's when you're talking about the curtilage. Scalia, with the famous case about
Usually,
the curtilage. So in the self-defense context, I really haven't found any cases that really deal with the curtilage in terms of the castle doctrine. Because usually, for those of you who know, the castle doctrine is usually somebody trying to break into your house. And here, you don't really have that. You have somebody who's on the curtilage, and the person wasn't really trying to break in. But it always comes down to, I think this case is going to come down to, in that moment, when after, I believe Chad Reed threw Kyle, maybe 10 feet, and then Kyle stops, and he points the gun. Is there an imminent threat to Kyle? Right, because that's going to be the question. For those of you who don't know, with self-defense, there are generally 4 criteria. You can't provoke it. It has to be an imminent threat. You can only use proportional force, only the force necessary to stop the threat, and your beliefs have to be reasonable. And here, I think the key question of this case is whether, at that moment he pulled the trigger, was he faced with an imminent threat of deadly force? And if he wasn't, that's murder. If he was, then he's in self-defense. So that's where I'm kind of like, I just don't know. I can see it happening both ways.
So first off, we've got New Chris asked if we are going to be taking questions in this live. Yes, we'll take some at the end.
Sure.
After we kind of talk through some stuff. But so to me, that is the big question with the Reed Carruth case, and that's where the second vantage point in the second video I think shows that his hands were just down at his side as he's standing on the porch after he threw him. He's far enough away. He points the gun. He sets himself. He gets his base in an athletic stance, basically. And no, in my opinion, I didn't see a lot of threat of imminent danger and harm and deadly force or anything like that. Yes, there were verbal threats made, which again is another comparison to the Kyle Rittenhouse case. He said, you better use it or I'm going to take it and use it on you. All of that happened. But to me, so much of it was not a threat of physical violence, where he's threatening to take him to court, to subpoena him, to get his kid because he deserves his kid, yelling at his ex-wife, yelling at her boyfriend. I didn't see a lot of, oh, this is going to turn deadly as you watch the beginning of that video.
Yeah, and so people understand, to provocation, generally, words are not enough. Right. If no matter what someone says to you, generally words are not enough. And so people understand there are 2 types of provocation. There's criminal provocation, which I like to call provocation by default. Right. If you're committing a crime like robbery, then legally you're kind of automatically known to be the provocateur. Right. And you can't claim self-defense. So that's criminal provocation. Right. And that's essentially what happened in the Arbery case. It was criminal provocation. They were committing a felony false imprisonment or even aggravated assault. But here, I don't think you have that criminal provocation. The second type is the non-criminal version of provocation. Now, the courts are very, very, it's a very rare to have the non-criminal version of provocation. An example of that would be adultery. You walk in and you see your wife in bed with another man. That's a form of non-criminal provocation. And so everyone understands what non-criminal provocation is. Essentially, I have it written down here. It is, I'm just getting a. It is something that causes a reasonable person to lose control. That's what non-criminal provocation is. And so the law is very, very, because the law doesn't like to recognize, to allow people to just lose control and kill other people or do something like that without some type of consequences. So that's why the bar for non-criminal provocation is pretty high. But here, I really don't see that for either person. The closest it comes to is when Kyle shoots at the floor at that time. you may have an assault, but even Texas law allows that, because Texas law allows you to threaten deadly physical force if you feel that someone is trying to employ deadly physical force against you. So even that shooting at the floor, if you were in New York, that's an aggravated assault, and he doesn't, and Kyle would not be able to use a self-defense claim. It's done. He's done. Right? That shot to the floor would have killed any self-defense claim. In Texas, he's still okay. So whether there was, I don't think the provocation here is I don't think this case in Texas loses on provocation because of those two things. Texas is very, very strict on what provocation is. And on top of that, I just don't see it. And having a gun is not provocation either. A lot of people have been saying, "Oh, he had a gun." That's not provocation. If you're allowed to have the weapon, and that was the argument that we used in the Kyle Rittenhouse case. He had a gun. He provoked it. No, having a gun in an open carry state is just, you can do it. So it's not, you can't provoke someone by having a legal weapon. That just doesn't happen.
Yeah, and I think the thing with verbal threats is some people have a hard time understanding that verbal threats are not enough. And one of the connecting and important aspects of a verbal threat is, could that person actually make good on the threat? That's why a lot of things over the internet or phone calls you're not in reasonable fear for your life. If I send you a text message, I'm going to come shoot you. Okay, that's not immediate right there that now you can come kill me. If I show up with a gun and I say I'm going to shoot you, then that verbal threat can show that I'm going to use deadly force on you, which then you can respond with deadly force. So I think that's one of the interesting aspects of the situation. I think where this case hinges is, was he in fear reasonably of imminent bodily danger at the time he pulled the trigger? And to me, that's where I'm hung up on whether or not this was justified. Because he wasn't thrown to the ground and then somebody ran over and kicked him in the head and tried to grab his gun. Like, he just was tossed to the side 6 feet and standing there with his gun still.
Yeah, I'm going to show you, this is one of my slides for my video later today, because I do slides on everything because it helps me.
Absolutely, yeah, go for it.
If you could share this is at the point right before the shooting, right? So that distance between, the question here is going to be simple: whether this person was an imminent threat, right, of causing Kyle serious physical injury or death. He has no weapon, and he's maybe about 10 to 15 feet away. So he's a runaway. This is totally different from Kyle, because with Kyle Rittenhouse, Rosenbaum was right on him, right? He was right there, lunging. Boom, and that's when he shot.
And the whole charging element, too.
Yes. Here, do you really have, if you're on the jury now, I'll ask the people in the chat, if you're on the jury and you see this picture, right, and know that the shots are about to be fired at this distance, is it reasonable for this person to believe that Chad is a threat of serious death or physical injury to Kyle? This is where I think it doesn't look good for Kyle. I'm just saying, in my opinion. In New York, he would be charged with murder. In Texas, it could be a different story.
Right, I agree, and I think that's kind of where the gray area is right now, which is going to make this case interesting, and we'll keep following it and see, what happens as it progresses. But switching gears kind of back to the Rittenhouse case now, have you seen or commented on the NBC producers that were following the jury and the body cam footage that came out? Did you see all that?
Yeah, I did. And now I saw did you see the body cam? Yeah, that was crazy. It was just like, what?
So what do you think, if any, could be some potential legal ramifications for media outlets that did stuff like this in a trial like the Kyle Rittenhouse case?
Well, I don't know, because there are two things. Number one, you do have freedom of the press, so I think that may be a bar to as far as you can go, right? It's just like freedom of speech essentially. But I also think that they do have the guy ran a red light. He's following the van, so maybe if you can find some, maybe contempt of court or something like that. I'm not sure the implications for the people involved, but I think it's definitely a bad knock to NBC, because especially the way they've been covering the case, they've not been covering the case fairly at all. They've made Kyle up to be a white supremacist who was an active shooter, went out there and just killed everybody, which I think is not the story at all. And I think this just kind of puts people back into the place where the news media is less likely to be trusted, because why the hell are you following the jury bus, right? It almost made no sense. What were they trying to achieve? So I think the producer of NBC and the person who was doing it, they should be, there should be questions and investigation on that. But I don't see how far it can go to the actual news media organization, because they're going to wipe their hands of it. Hey,
to
they
me,
did it on their own.
it's what the interesting factors are. So I don't think they violated a court order or anything like that. If there was a court order telling them not to do it and they violated it, I think there could be some issues there that they'd have to deal with. But I think the bigger issue is something that, we've seen after the George Floyd case, where some jurors come out and are interviewed and speak and whatever it may be. If any jurors from the Rittenhouse case do that, or if there are any threats or violence or anything that happens to their property or person of the jurors that were in the Rittenhouse case, I think that there could be some potential civil charges they could look back at as, did this reveal our identity? Did people like this that were the news media outlets following us, knowing that what good is going to come from this? What good is going to come from them following me as a juror, figuring out my identity, putting it out there for clicks or for ads or whatever it is that they're doing, and putting my safety in danger, knowing that the country is going to be upset no matter what the result is. In this case, there are going to be people that are irrationally upset. And they disregarded all that in order to go get a story. That's the bigger issue, I think. If something should happen to one of these jurors, did this affect the secrecy of their identity? That's the point of not letting this happen, right?
Oh yeah. But again, I would just need to see more facts to determine, because did they even know the identity of the juror, or was this the first time they followed them? Like there needs to be a little bit more facts to kind of get me to that point where I would say but no. The implications is, if something was to happen to one of the jurors or theirs, then NBC is going to have a lot to answer for, because now you start getting the investigation of who'd you call, who'd you tell, did you take pictures of these jurors? Who else knew? Because you're going to have to try to figure out how people found out who these people were. And the first place I would be going to is NBC News. And somebody in the chat said it was MSNBC. No, if you look at the if you look at the body cam, they made sure this is NBC. They didn't say MSNBC. They said it's NBC.
So yeah, and I think that's, to me, it's just really interesting to think we all act like we want to come together as a country and we want everybody's safety. And we hope that no matter the outcome of the presidency, no matter the outcome of this trial, that we can all understand and be adults and work together. But then we're trying to stir stuff up, just as we have been over the last 5-10 years, to just make everybody go crazy, right? And this is just another reason where you're giving somebody a target to attack, should they want to attack, based on what the jury verdict is. And if you ever want to see somebody squirm or hear somebody squirm, go watch the body cam video and listen to the executive producer over in New York say things like, we were just trying to figure out where the key players were from the courtroom. They were very careful not to say, we were following the jury to try to figure out where they were staying and if we could find out the identity of any of the jurors. But that's exactly what they were doing, which I thought was funny, just to kind of listen to them squirm in real time. And that cop was super calm, super nice, and he knew exactly what was going on, which was hilarious. He was
let me speak to him on speakerphone.
And he's like putting the name right in his body cam so you could see the lady's name was Irene Bayon or something. And it was just so funny to see all of that happen, So I'm interested to see in future cases, because I think Judge Schroeder, let me ask you this. So one of the things I found interesting is that he would respond from time to time to things that were said on media outlets about decisions he would make or things that were happening in his courtroom. In your experience, do you think that is something that is very new and different in today's day and age and would never have happened in the past? Or do you think it's something that's always happened, it just we're watching it live stream today?
I think it's the nature of this trial and the publicity that the trial is getting. Because 90% of the time, like, I've never had a case where, I had people following it in the courtroom with cameras. I've never been a part of that. But I can understand that a judge being a part of that and wanting people to. I think the issue with this judge wasn't the rulings that he was making, but the mischaracterization on why he was making the rulings that he was making, right? Like, for instance, MSNBC, since we're talking about them, they were saying that the judge, they almost made it seem like the judge was a racist, and on top of that, because of his ringtone, and on top of that was a Kyle supporter, right? He was secretly working for Kyle. And even with CNN's analysis of what was going on, it was really, really skewed in one direction. The judge has to be wrong, like the whole victims thing, right? Instead of saying, well, this is the way this judge rules on all his cases, right? He never lets the defense call the defendant victims because it's something that's the purview of the jury. They say, well, in this case, he did it for Kyle. And that's just not true. So I understand the frustration with it. And then I understand why the judge is saying, well, now I'm going to think about whether I'm going to allow cameras in the courtroom in future trials if they're not going to report accurately on what's actually going on or give it the proper context. So I do understand that, but I never think, but I think the judge is wrong in that sense, because taking the cameras out of the courtroom is just putting back the secrecy and not letting people into the process. Because, like, for instance, Nick Recchietta and the rest of us, we saw what happened and we were able to defend that and say, no, this judge was right. This is the right ruling. This is what happens every day. And I think the judge has to understand that there are always going to be people that are going to say bad things. There are going to be people who are going to say good things, but you got to take them both. And you got to hope that rational people understand what's actually going on to line up those dots.
And the cameras just are in support of what actually happened. So, I mean, I don't know how
exactly
taking the cameras out would help that, because the reporters are still going to be sitting there reporting incorrectly. And, that's what's going to happen. I just think the whole following the jury, the reporting in that case, and lots of cases solidified the fact that no matter what side you're on, basically, politically or morally or any way, you just can't really believe what anybody's saying, because everybody's got their own agendas. Everybody's got the reason they're trying to push certain things and get certain points across and agendas across. And I think that that's going to be difficult for us to deal with in the future, generally speaking. I also think it was just so unusual for people to see what I'll call a defense-friendly judge, right? He wasn't a Kyle supporter, in my opinion, but he was just a judge protecting the rights of a criminal defendant, which does happen from time to time. But it's very unusual. They're usually just former prosecutors, hard in the bag for the prosecution, letting the prosecutor run the show, do whatever they want to do. I've had cases where, let's just say to make it easy for everybody listening in the chat, where we have a business records exception affidavit signed, so these records are authentic, and they have to come into evidence, and the judge would look at the prosecutor and say, do you have an objection? Like, judge, it doesn't matter whether they have an objection or not. This comes in. This is what the case law says. And they would not let them in until the state was okay with it. So we had to talk to a supervising prosecutor to say, you don't have an argument. Just say no objection. So they come in, which they did. But that's a normal judge who is always on the side of the prosecution. And I think that's why it was so unusual that they were actually just protecting the rights of the criminal defendant, which is what you want, so that they don't win an appeal if they get rightfully convicted. But people don't understand that. And I think it was a shock to the system to see that. But one of your videos, I did hear you have some rather strong words for Binger. And I think you called him something like corrupt, or I don't know if it was perpetuating perjury. I don't want to put words in your mouth, but using perjury or whatever it may be. So tell me about what you think about how the prosecutor handled this, because I think that has a difference with how the judge acted as well, because this isn't the first time the judge has seen this prosecutor. You're on mute. I think you muted it for the sirens or something.
For the sirens, yeah.
Go for it.
Yeah, this prosecutor, the problem with this prosecutor is that, so everyone understands, the ethical code for lawyers here in New York, and I think more or less nationwide, is that prosecutors are supposed to seek justice, not convictions, right? So, and what that means is that the prosecutor essentially even represents the defendant, because the defendant, that's why they call them the people of the state of New York versus this person. So you're representing the interests of justice. You're not trying to just convict to have high conviction rates. And in this case, I could actually see someone bringing charges against this prosecutor, because even from the opening statement, for instance, the opening statement was such where I was shocked, but he said the evidence is going to show that Kyle Rittenhouse chased down Joseph Rosenbaum, confronted him, and shot him in the back. And then he goes on to put all his witnesses on that said the exact opposite, right? No, that's not what happened. And think about this, and this should scare everybody out there. This prosecution had two theories of the case that were diametrically opposed. Their first theory was that Kyle was a active shooter who went to the protest to kill people, right? If you listen to some news media, say it would kill black people, but he was an active shooter that was going around killing people, and these people were trying to stop him from killing more people. That was the prosecutor's initial, and that's why he said, the evidence is going to show that Kyle Rittenhouse chased down Joseph Rosenbaum and shot him in the back. But after the evidence was all presented and after all of their witnesses said that didn't happen, they had number two, which was, well, everything we said before was a lie. And now we're saying that Rosenbaum actually chased Kyle because Kyle provoked him. So that was a huge difference in the theory of the case. And that's textbook reasonable doubt. That's textbook reasonable doubt. And my argument against this prosecution is they violated this poor kid's constitutional rights, right? His Fifth Amendment right to privilege. Then they go and use propensity evidence that they weren't able to use. And they were trying to use every dirty trick in the book to get this kid, like even having the two witnesses come on who everyone knew was lying, right? Even the police in the report said these people are being untruthful. The owners of the car source who said, we didn't ask anybody to come, even though they've got pictures of them, even though they got text messages, they obviously asked these people to come to protect their business. Remember they had the interview with a owner of the car source that, yeah, we lost about $2.4 million in damage. And don't understand, he's like, well, I don't know how much we lost. I think it was about 400,000. Yeah. Who really knows, right? These people were obviously lying. And for a prosecutor to put someone on the stand and ask them those questions and know that they're going to give you questions that are questionable, that are essentially lies, then I think, yeah, this prosecutor, someone should look at this and determine whether this is the way we want prosecutions to run. Right. I understand having a losing case and doing it ethically and just saying, okay, well, here's the facts and here's the evidence and good luck with it, versus what this prosecutor did, mischaracterizing the evidence and straight up lying about what he was going to prove and then changing the story and at the end of the trial. That's not something we should all be fearful of.
What's funny is I was breaking down parts of the trial and I was talking about the opening statements. And as I talked through the prosecutor's opening statement, all these people in the chat were like, that didn't happen. He didn't get shot in the back. They weren't. I'm like, guys, I'm talking about what the prosecutor said in his opening that he's going to prove. Let's see if he proves it. And that's what jurors are supposed to do. Take note, mental or written, what they say in opening, see if that's what their evidence proves, and then make your decision at the end of the case. But you don't just disregard it if they don't prove it, or actually if the witnesses say the exact opposite. The shooting unarmed people and shooting them in the back after chasing them, those are big buzzwords and misstatements of fact that I thought the prosecutor really ate after his opening. And I also thought it was crazy how his whole case was riding on Gage, and he didn't know what Gage was going to say because he never actually got to take that second full depo because Gage had a lawyer, pled the fifth. And yet you put him on the stand, and that's your whole case, and it blew up in his face, basically. And that's just very unusual for prosecutors not to know what their witnesses are going to say, or, as some of the other witnesses, knowing what they're going to say is bad for you, and they sound like a defense witness. It was very surprising to me. And I've on this channel many times talked about how frustrating it is that witnesses can just take the stand and perjure themselves, and there are really no repercussions. We always say, under penalty of perjury, you could go to prison for 5 years. That's what we say here, because that's what it is in Florida. But that never really happens unless you're a criminal defendant who takes the stand and the judge thinks you lied, then they can add 5 years to your sentence. But it never actually happens to lay witnesses or alleged victims or anything like that. And that's frustrating to me. What are your feelings on that?
Yeah, no, you're 100% right. But I think in this particular case, especially with Grotskreutz, Grotskreutz straight up lied a couple of times on the stand. And like you're saying, he's not going to have, like, for instance, his permit, right? He said that his permit expired. But now we have the permit, right? And we saw the permit and it didn't expire. He lost the permit because he had been found guilty in a criminal prosecution. And one of the things that happens is that you lose your permit, right? So they had his permit, and his permit was actually good to 2022. But on the stand, he said, my permit expired. Now, something like that's obviously something that perjurous, right? That's something that he knows that his permit had expired. He knows that it has been revoked because of this issue. And this was one of the most frustrating things about the defense too, is that they should have known that before he took the stand. They should have subpoenaed that record of his license from whatever that licensing agency is, and had that. So when he said that was checked that right off the box. Oh, you said your license expired, right? Are you sure it expired? Well, here's your license. What's the expiration date? But I think the defense, technical issues with the defense I've had, but they won the case. But I also think they made this case a lot more difficult than it had to be, because I don't think they should have put him in the case at all. I think they should have rested right after the prosecution closed, because the prosecution proved their case.
It's hard. It's hard to do that, as you know.
It's hard.
Especially
It's
when
difficult.
you have all
It's
this
very
prep.
difficult.
It's easier for us to sit here and say than to actually do it while the world is watching. Because if they would have lost doing that, you know how the opposite side would have reacted to that.
That's true. But
yeah.
I don't think you could lose though. I'm talking about, honestly, if they rest right after the prosecution closed, all the evidence the prosecution put on, every single piece of evidence showed that Rittenhouse was self-defense. Matter of fact, the only way they were able to even get provocation in is because the defense put Rittenhouse on the stand, and they were able to show, all right, we got a little provocation here at the end. That was it. That was the only way they even got that in. So, but you're right, though. This is Monday morning quarterbacking. So
exactly right. But hey,
it could have been both ways.
Yeah, but I also think putting Rittenhouse on did show his state of mind for self-defense too, and what reasonable fear he was in. So I mean, I can see why they struggled with the decision. Just to put it to give a little grace to a practicing criminal defense lawyer, But there was something else I was going to say about Binger. I can't remember.
Yeah, Binger. Okay. Binger made I think a lot of people. I think it woke a lot of people up to what happens when the state is trying to get a conviction versus trying to look for justice. Because I think we all saw that. We all saw prosecutors trying to just get a conviction by almost any means necessary. With and that's, I think, what scares a lot of people now. A lot more people are scared now of the system, and I think Binger helped expose that part of the system.
Yeah, and that's horrible, and that's something you learn early on as a prosecutor. What you're supposed to do is seek justice, like you said. So what I was going to say is about the permit. So one thing that's interesting that I've actually had happen in trials, and I don't know if it happened in this case. I didn't follow every hearing and motion and stuff that they did throughout the case, but I've actually had judges allow witnesses to give a story like that in order to not allow in inadmissible evidence that's overly prejudicial and not probative, and let them say something like that that's technically not true, but gets the point across that he did not, in fact, have an active permit at the time, but they didn't want to get into his past convictions potentially. So they just say something bland and vanilla like it expired, which lets the jury know he was unlawfully carrying a weapon, but doesn't tell them about his previous crimes, as to not think, oh, it's okay that Kyle went out and killed these criminals, and so let's let him off because of that. So I actually have had stuff like that happen before where we're not allowed to cross him and say, it didn't expire. In fact, you're a convicted felon, and that's why you can't carry a firearm. Isn't that right? Judge wouldn't let us even ask those questions. So that has actually happened to me in cases. It's very frustrating, and I strongly objected, no matter, even the judge doesn't care when you strongly object, but lawyers love to do it. So that's just an interesting, side conversation.
Oh, yeah. No, I definitely agree. Like, for instance, if it's a criminal defendant, and the person says it's expired versus that, then I understand, because you may not want to get the propensity evidence in, especially if it's a criminal defendant. But I think for a witness, especially a fact witness, is this witness, and you're trying to impeach his credibility a little bit, I would have at least I'd at least attempted to take the shot. But if the judge knocks it down, then okay. At least I made an attempt.
I agree. So how do you think these three cases, if at all, will affect gun charges and regulation and things like that in the country? Do you think they'll have an effect, since they're so high profile, all hitting literally one right after the other?
Well, first, Kyle Rittenhouse, I don't think is really going to change anything, because first let me start in Georgia with Arbery. Arbery's case did change stuff in Georgia, right? That's that statute for citizens arrest is now debunked, right? They actually went and changed the law, and both Republicans and Democrats saw how that law was being bastardized and said, we don't like this, and no one should be able to do this ever again, or even attempt to believe that they're justified in doing something. So they repealed that law and put something new. So that's a good change in there. But now with gun culture and gun laws, I think the argument that I see from the left a lot about Kyle Rittenhouse is that he shouldn't have been there, and he shouldn't have been there with a gun. And to me, that argument is nonsense at best. And the reason why I'll say this is because Kyle Rittenhouse had a legal right to be where he was at, right? The curfew was not enforceable. So he had a legal right to be there, and the weapon he had was legal, right? They were charged with it, and they dismissed it because they said, well, it was long barreled, so it was legal. So he had a legal weapon, and and anywhere in the country that allows you to open carry, as long as the weapon is a certain amount, then I understand. Then, if he's walking down the street with the weapon, that doesn't allow someone to say, oh, he's a threat and I can attack him at that point because he has a weapon. I don't like it. Well, your problem is not with Kyle. It's actually with the laws that are in Wisconsin that allows people to do it. And it was interesting because even during the trial, there was a 16-year-old with her father who were walking outside with AR-15s, walking around, right? And people were saying, oh, this, and they happen to be black. And they were like, oh, these black people walking around with AR-15s. But it shows you how I don't think it's going to change gun culture or the laws when it turns to that. I don't think either one of the cases in Texas, Wisconsin, or in Georgia, because those are two very heavily great two-way states. But I do think it's going to have a conversation about maybe, to what extent are we going to allow citizens to take the law into their own hands? And I think in Georgia, that's where you really got the epicenter of that. We don't want people doing what they did. But versus in Wisconsin, where I think most people who understand the facts would say we do want someone who is in Kyle Rittenhouse's shoes to do what he did, right? If someone is chasing you down and screaming F you and lunging for your weapon and threatening to kill you, that's what the gun is for. And he's used it based on what it's supposed to be used for.
So one of the things I think with Kyle Rittenhouse that I said kind of throughout the trial, personally speaking, right? Not legally speaking, because I agree with you. Technically, and that's why the charges were dismissed or dropped by the state, the curfew charge and the gun charge. What he was doing was not technically illegal. I still think it was unwise personally. That's just my opinion.
Yeah.
And
I agree with that.
Most of the nation, and most of the nation didn't show up there, especially didn't let our kids show up there with guns. So I don't think that's a groundbreaking statement to make. But technically, it was not illegal. I think what should be learned from the Kyle Rittenhouse situation is we don't want anarchy. We don't want a country where we defund the police or we let people, riot and loot and do those things, no matter what their reason is, right? Peaceful protest, go for it. Marching, go for it. March on Washington, whatever. Do it. Like, that's great, especially with YouTube and media outlets and TV and how you can spread awareness of different situations you think are important. Do it. Use those opportunities and those platforms that you have. But what doesn't work is when you do things that create a chaotic situation, which is exactly what I thought the defense, their theme was of the case is this was like a war zone. This was anarchy. This was crazy. Everybody was throwing stuff. All the guys that took the stand that were, there at the gas station with Kyle, they were like, yeah, they were throwing gas bombs and big rocks, but I wasn't in fear for my life. It's like, oh, that's normal for people to be throwing like gas bombs at you in the middle of the street? No, that's the situation that we were in that we don't want to get in as a country. Because if Kyle Rittenhouse is walking down a street here in Tampa Bay where I live, and he's got that AR-15 and he shoots 3 people, that's not going to be self-defense. But if it's a war zone out there and people are lighting stuff on fire and throwing bricks through windows and threatening people and yelling and doing all this crazy stuff, that opens up this situation that we had. So to me, it was a much bigger conversation than guns, anti-gun, pro-self-defense, whatever. To me, it was, we see how this works where everybody wants to do whatever they want to do. Generally, people make bad decisions. And more often than not, this is what it turns into. And none of us want this outcome. None of us should want this outcome. So even though I think the result of the trial was correct, I think wiser decisions could have been made to prevent a lot of the chaos and death that happened that night, personally.
Yeah, if it's interesting because I'm torn with this question about what should have Kyle done, right? And for instance, when Kyle effectively was asked to be a security guard, right? Be a security guard for this business, right? And if he put on a uniform and got a little fake badge and was out there, all the paperwork was right, and he was employed as a security guard, we'd be having a whole different question, right? Because we'd say, okay, he was employed as a security guard, but this was an off the books security firm, right? Okay, you can legally be there with a gun and just be out there on our property, and guess what? We're going to make you a security guard for this business. And a lot of the counter arguments would be like, well, he's protecting a business that's not his. That's the security, that's security all over the country, right? The security guards in stores and malls that are protecting businesses that are not theirs, right? They're being paid and asked to do this from some other people. And that's what essentially happened here. And I do believe as a 17-year-old, should he have been there? Probably not, right? But to be honest with you, nobody should have been there, right? Even those protesters shouldn't have been there at that time.
It was
Because what they were
unwise for everybody
protesting,
to act like that.
yeah, what those protesters were being there for was actually a lie, right? The Jacob Blake situation was technically a lie. The fact that he did get shot in the back, but the news media portrayed it as this was an unjustified shooting. But then a couple of months later, you find out he had a knife. He fought with police. There was an arrest warrant, and police did everything possible to stop him from going to the car. And he went into the car to grab something. You know, he was shot. So it was I think it was bad decisions all around. But I always like to, and that's what I love to do with when I try to analyze these legal issues, is just say, okay, in this moment, the only thing we can, I can't say that what he did, I can morally judge it and say I wouldn't have my kids out there, but the fact that he was out there and he had a right to be out there, does that mean that he should in any way be held liable for the situation when someone attacked him, when these people attacked him? And that's where I say, well, I can't get on board with that, but I could say in the future, I don't believe Kyle Rittenhouse is going to go out there protecting any more car swords with AR-15s, right?
I hope
the lesson
not.
has been learned, yeah. But before that, it's like we were talking about earlier, Monday morning quarterbacking, right? Would you have done it? No, but the fact that he did do it, I still think that it's grounded in reason and fact, right? He wanted to help members of his community, and I'm assuming they were going to pay him something for it too. So I think it all depends on the framing. If you frame Kyle as a security guard, like the rest of those people who were there, they were security, then you kind of have a different outlook on why he was there and what he was doing.
Yeah, I agree. And I think that's the point, is it's two separate arguments, right? There's this overarching moral discussion we can have, but then legally speaking, you have to look at what actually happened and you have to base it off that. And juries cannot convict based off of an unwise decision at the beginning of the day. If that was the case, a lot more people would be convicted of the results of what happens from one bad decision, whether or not it was actually a criminal decision. All right, I'm going to jump in here to the chat, see if I see any questions. If anybody has any questions, go ahead and throw them in there now.
Here we go.
Are the feds beating a dead horse by charging the three men from the Ahmaud Arbery case in 2022? They were found guilty already. What happens to their state appeal if they were to win the federal case?
Well, separate sovereigns. So the feds and Georgia are two different sovereigns. What separate sovereigns means is that the feds can charge you for crimes, and the state can charge you for crimes, and there's no double jeopardy when that happens. But the feds are charging them for under the hate crime statute, which, because they were chasing him using an N-word, and after they shot him dead, you're holding shotguns over the dead body and still calling the N-word. You're gonna get hate crime charges for that. The state charges.
That's like the law school case of hate crimes.
yeah,
like literally.
I think when you go to the state charges, a lot of people are making a big deal about the way the statute for citizens arrest were interpreted. I do think that's a live appeal. I think you do. I would appeal it if I was their thing. I saw your video after the judge made the ruling. When you came on, you were like, "This case is over. The case is over." I was like, "Yeah, the case is definitely over." I saw your video on it, and for those of you who don't know what I'm talking about, the judge interpreted the I'm about to say self-defense, the citizens arrest statute.
Citizens arrest jury instruction, yeah.
Yeah, the citizens arrest jury instruction essentially said that if you're going to arrest somebody based on citizens arrest, it had to happen in that moment. You couldn't arrest someone today for a crime they committed 10 days earlier. And that essentially was the whole defense's argument. The defense's argument in the Arbery case was, on February 11th, Ahmaud Arbery committed crimes in our presence, and we were arresting him on February 23rd for those crimes committed on February 11th. They argued that for 2 whole weeks. They're opening, they're closing, 2 weeks. That was their whole argument. And then the jury instructions came, and the judge said, you can't do that. You can't arrest somebody on February 23rd for something they committed on February 11th. You would have to had seen the crime February 23rd. It would have had to happen in your presence, and you would have to arrest them contemporaneously with that. So that understanding is now, can be. It's going to be challenged in the Georgia State Court of Appeals, but to me, it seemed like the judge made the correct call, because that's the way I read the law. But differing minds can agree, and I think there's a real threat to that conviction if that reading is found to be inaccurate. So we'll see.
Yeah, absolutely. It gets overturned if that reading is inaccurate, obviously. But I can't think of because you've tried cases. I was so shocked that they didn't have an agreement or at least a contingency plan if this jury instruction was not going to be read the way that they thought. If I argued every jury instruction exactly the way I thought it was going to be read, we'd have problems. So usually that stuff as a trial lawyer beforehand. But yeah, I mean, I think it's interesting. I think, go ahead.
Shocking they didn't ask the judge. It was shocking they didn't even give, like, why would you build your whole case on this stupid jury instruction? And
that's a preliminary hearing you need to have.
What? We've been arguing this for the whole trial and it's wrong? It's like, yeah, it's wrong. Yeah, I don't know. Again, but do you think ineffective assistance of counsel? Do you think they got a shot at that?
I would.
Because
to me, I absolutely would. I would say, are you kidding me? Like, this is a preliminary hearing I have in every case. And we always know the couple jury instruction, like in personal injury cases in Florida, the non-joinder statute, we can't talk about whether or not the other person has insurance. But there's a collateral source jury instruction that lets us say things like, don't take into your mind whether or not the person has health insurance or whatever. Just give us the bills. We'll do the set off at the end. And some cases that jury instruction comes in, some it doesn't. So I don't build my whole case around it before I know whether it's coming in. There are certain jury instructions we dog ear and star that we don't know whether they're coming in or not, or how they're going to be read. You don't just argue and assume you're going to be right in a trial in an adversarial system. Like, that just was very shocking to me personally. All right, we've got, and I also think just to wrap this question, the fact that it's a hate crime, I think, makes a big difference as to why the feds are not just necessarily beating a dead horse. They probably want to make a point with that. So that could make it different. And if they win the federal case, it doesn't affect the state appeal. Two totally different things, like you said. All right, Joe to go. Do you think it was a good idea to use Kyle Rittenhouse as a witness for the defense? Go ahead. I think we potentially have differing opinions on this. So go ahead, tell us why it was not a good idea.
Yeah, I think a trial is about strategy. I'm a chess player. I'm ranked a master in chess, and I always kind of analogize. Trials to chess in terms of strategy. And sometimes you'll go in with the strategy, and that strategy will be, hey, I'm going to put this defendant on. I'm going to tell this story, right? Because you have to go in knowing what you're going to do. But then when you see the other, it's like playing poker and you see the other person's hand and you say, well, you don't have anything. You have a high card. The highest card you have is a 7 of spades or something like that. And I'm holding aces, right? Then it's like, well, at that point in time, then there's diminishing returns. So watching the trial live, because I watched virtually every minute of the trial, watching the trial live, I'm seeing the opening statement, putting that together with all the witnesses they put on the stand, and then the Gross-Kreutz admission that Kyle only shot him after he pointed the gun at his forehead. It kind of made me think, well, at this moment in trial, because that's what you have to do. You have to kind of always reevaluate. And I think if you reevaluate it at that point in time, how has this hurt us? How has the prosecution's case hurt us? And at that point in time, I didn't see how the prosecution essentially proved that Kyle was justified in using self-defense. And I think you could have argued that in closing, like, hey, here's the prosecutor said in opening, he's what this witness said, he's what this witness said, it's all lies, he's wrong, and let's go home. But having Kyle go on, it did hurt the defense. It hurt them in the provocation jury instruction at the end, because they used Kyle's testimony to say, well, he provoked Rosenbaum, and then that's when they were able to get that. So it did hurt them at the end, but did it help? It did help because Kyle was a very believable witness. So I juries do want to hear from the criminal defendants. Why did you do this? And see them hold up under pressure. So for me, I wouldn't have put them up. But putting them up, I do understand they did get value. I think they got dinged a little bit for it, and they won the case. But I would have put him up. But again, that may be just more style points rather than the proper tactic in that moment. So,
yeah, I don't necessarily think either one was a guaranteed result, putting him on or not putting him on. So I could see arguments for both, and I think you made some great arguments why not to put him up. I see some benefits putting him up in the analysis that I usually do in my head about every witness, not just a criminal defendant, but a plaintiff in a PI case, whatever it may be, is, are they believable when we go through their testimony? So I think they could probably tell he was going to be a good witness. So that's number one. Number two, juries always want to hear from the person. I don't really care what anybody says. They always want to. Not that they won't convict if they hear it, or that they won't come back not guilty if they don't hear it. There's no like exact equation for that, but they always want to hear the defendant say I didn't do it, or give his state of mind, which I think was important in this case as to why it was self-defense, and why he was in fear. I think that was really important. And a big part of the analysis that comes into me, especially in criminal defense cases, is do they already have statements by the defendant? Are those statements going to be pretty consistent with what he testifies to? Will any of those statements hurt me? Is there anything he can be seriously impeached on? And I didn't feel like Kyle had a lot of impeachable events or things that they could say, oh, you did this, not this, or you actually shot him 6 times and you said you shot him 4 times, or whatever it may be, anything big. Now, they really harped on the fact that he wasn't technically an EMT, which I thought was a dumb argument to just like harp on. Like, he was there trying to help people. The fact that he wasn't, are you going to sue him for malpractice or practicing medicine without a license? Is that what we're here for? That was a dumb argument to me, but that's why they kept saying, oh, he lied about that. He could lie about everything. It's like, well, we have the video. And when you have the video, I think having Kyle narrate the video was effective, in my opinion. I don't think the defense attorneys were perfect. I liked some of what they did. I didn't like some of the other things that they did, but generally I could understand why they put Kyle on the stand. And I think it did have some benefits, and it also had some negatives as well, which is going to happen with just about every witness.
That's true. But I agree with you. Kyle was a net benefit than a net loss. I think the provocation was a risk because they did get provocation, but I do think it was a net benefit because he just came off so believable, and it was good. But again, even going back now, I would have put him on because I just think the prosecution's case was just so bad, so poor. It was really bad.
So it seems like this same guy, Joe DeGo, maybe thinks he was not a good witness. So wouldn't Kyle be unreliable as a witness because he was on trial? How would he be trustworthy? So I think this goes to the bias of having an interest in the outcome of the case. So I don't know if he's thinking he wasn't reliable, or if he's just saying they could knock him and say, obviously he's going to say whatever he needs to be acquitted. So how do you deal with thinking about witnesses that have an outcome in the case? And does that come into your analysis as to whether or not you're gonna call them? And do you think that hurt Kyle?
Well, here, this kind of, it seems like the person's trying to say a bias, because every witness has a bias, and bias is always relevant.
Especially parties.
Yeah. Especially parties. So Kyle, being the defendant, obviously he's going to tell the story in the best light possible for him. But you've already had the state put up its case. You've already had the videos. You already had this. So I think there was a lot less risk for Kyle in this particular piece because he's just really walking you through the evidence that's already been induced, right? You already had McGinnis up there saying the guy lunged at the gun and screamed "F you," right? So Kyle is just really just going on and saying, yeah, I was there too, and what McGinnis said was true. So he had a lot to work with, and just like you said, Kyle didn't have a lot of those statements, those impeachable statements. You said this before, you said that before, you said this before, you said that before. If you want to see something like that, look at the McMichaels trial. The McMichaels trial, he had a lot of statements that he had to say, well, I didn't mean to say that, or I shouldn't have said that. Or as soon as you start saying, at what point they had him holding the statements full of lies, and he was like,
not good. It's not good when that happens.
And he's holding all the statements. He's like, yeah, I said it, but I didn't mean it. Like, what do you do?
And you know what you didn't say was citizen's arrest. So you have all the statements, but never did you say you were making a citizen's arrest out of all the statements you were saying that night.
Or you didn't even say why you're arresting him. I didn't ask you why you're arresting him. Yeah, you said, I don't know what he did. Duh, it's like, but in both those cases, I think it's interesting because even though how disastrous the McMichaels case was, I think they had no choice but to put McMichaels on the stand, right? They had no choice because their case was shit unless they were able to put him on the stand and had him explain what you guys were doing out there. So, in Rittenhouse's case, I think it worked, but I think all the reasons that you said why not to put someone on the stand was the same what happened in the McMichaels case. So
exactly. Yep. All right. What did you think about Kyle admitting his gun jammed and then he unjammed it on Tucker Carlson? So I didn't see this. Did you see it?
I didn't see that. No, I didn't see that at all. If he did.
Yeah. I don't know. I don't think it would affect anything at this point, but I did not see that.
Let's say the gun was jammed and he unjammed it. You still got somebody pointing a gun at your face. At that point, they were in a Mexican standoff. Right, they were there. One guy, and it was the first to the trigger at that point in time. So, I don't think that
I
changes
think that
his claim to self-defense.
right. Yeah, I don't think it does at all. Maybe it's makes Gage more believable, I guess, but to me, I don't think that really changes much. There was another question I was going to ask as a follow-up on the prior one about Kyle's statements. Oh, okay, so one thing people don't understand about, bias or having an outcome in the case, right? So I want to touch on this real quick. Um, when you take the stand as a criminal defendant, usually the state doesn't even make that argument because it's so obvious that you have an outcome, an interest in the outcome of the case. Same thing as a plaintiff and a defendant in a personal injury case. Like, obviously they have interest in the outcome of the case. That doesn't mean they're not going to testify, but in the credibility of witnesses jury instruction, which I feel like I reference all the time on this channel, you're allowed to say things like you can disregard some of what they say or all of what they say if you feel like they are so biased that what they're telling is just not the truth. But one of the ways you can reinforce that with the McMichaels is with other inconsistent statements that were made closer in time and proximity to the event. So which statements are more likely true? And is he more likely to come change his story, which was literally the prosecutor's argument that this whole citizen's arrest was created by the lawyers for trial. And that's reiterated and reinforced by the fact that he never said any of this until he took the stand at trial today. He had an opportunity to explain to the cops why this was a citizen's arrest, and he never did. So I thought that was a really good argument for the prosecutor. So why don't you, let's take a second here real quick. Contrast Binger to the prosecutor in the Arbery case. What differences did you notice? Did you feel like she did a good job? I thought she was awesome.
Yeah. Oh, yeah. The prosecutor well, I do want to say this. Binger's probably, if Binger had the facts for the Arbery case,
correct.
I think he would have done a great job. Yeah, because the facts in that case were so overwhelming for the prosecutor. It's just like, I remember when she asked the question. She was like, "Did he ever say I'm arresting them on fill in the blank?" He was like, "No." Fill in the blank is anything. Just say you arrest him for anything. He never even said he was arrested. So, even though she did a fantastic job, she was on her toes, timely objections. Her cross-examinations were excellent. Her closing was excellent. So I do think she did an excellent job, but I really think it was really determinative of the facts. She had the facts were so much on her side. It was crazy. And I think on the opposite part of it, Binger, just all the facts were against him. I honestly think you could make an argument that he should have never even brought the charges against Kyle, even though you have two people dead and all that stuff. But after the facts come forward, it's kind of like, well, can we really get a conviction based on these facts? And the way you can tell that, I think the reason why I believe that they should have never brought the charges is because of the way they had to change strategy at the last day of the trial. Remember, for 2 weeks, they had been saying Kyle was an active shooter going out there to intentionally kill people. And at the last day of trial, they said none of that was true. Now, Kyle provoked Rosenbaum and then killed Rosenbaum through provocation, and the other ones thought he was an active shooter mistakenly and tried to arrest him, and then Kyle should have been held responsible for those other ones too. So that dramatic change shows you that they never really had a case to begin with, and they were trying to fit it inside this, fit that square peg in that round hole. Where in Georgia, the case was obvious, right? And especially after the jury instruction, because I saw your thing. You were like, "Oh my God, how could the defense attorney? It's over. It's essentially they're going to be found guilty." You called it a week early, and we all called it a week early, right? Because it was so obvious. So I think those.
How fun would that case have been to prosecute? That's what I think about when I watch these cases. Just how fun would that have been to prosecute? Like, they've already waived they lost. Like,
yeah, you've already waived the defense, right? Oh wait. Think about how crazy it is. The defense attorney for 2 weeks is arguing in court that his defendants are guilty and didn't even realize it. Is that ineffective assistance of counsel or what? 2 weeks he's arguing his defense.
That's what I think, man. That's what I think their best appellate chance is. All right, so we're getting close to an hour here, but I want to get to this before we close it up. If you have any more questions, get them in the chat now. So when we've talked about already, and you've already mentioned that you thought Binger shouldn't have even brought the charges potentially against Kyle, and whoever the prosecutor is with law enforcement in Texas has decided not to bring charges at this point. So as a former prosecutor, talk about what that process is like, determining whether or not you're going to bring charges, who you talk to, what you consider, and why there are important factors and decisions being made in the background that we are not privy to at this point in all of these cases.
Well, when I was in law enforcement for a long time too, and it's kind of, you're talking about the same standard to bring charges for prosecutors and law enforcement are the same. It's probable cause. Prosecutors are law enforcement, but whether you have a crime and you can say this person, you can reasonably believe this person committed this crime, right? You had some facts and evidence to show that. Here, the crime would be some type, either I wouldn't say he intended to kill him, because I don't think you have malice murder here, but you're talking about some type of manslaughter charge or some type of reckless homicide, something, or even some culpable negligence, right? So in this case, what facts do we have that kind of support that? We have the video, right? And that's what it's going to come down to. We have the video. Why was he there? What's going to be the defense? And the prosecutor is going to have to prove, because after an affirmative defense is raised, like self-defense, the prosecutor has to prove that this person wasn't acting in self-defense beyond a reasonable doubt. So he's obviously said he's going to raise self-defense. So now, can I prove that that didn't happen beyond a reasonable doubt? And that's where I go to that picture. When he throws him, is there enough? Now, I don't have to prove it to an absolute fact, but can I convince a jury that at that moment, when he's 10 feet away pointing that gun, before he pulls the trigger, was he being threatened to the point where a reasonable person standing in his position with that gun would believe that Chad was an imminent threat to his life, was able to cause him serious physical injury or death from that picture, from that position? I would be able to bring charges and I would be able to argue that to a jury. But I'm not sure if in Texas, whether, because this guy's, I think family's got some, he's, with law enforcement and judges and all that other stuff. But that's where I would be. I would say, could I prove that beyond a reasonable doubt? It seems like it's possible I could. But again, it really depends on the charge and the prosecutor. But I would charge this guy. But I don't know what they're going to do in Texas.
And what's happening in the background is this guy and Kyle Rittenhouse both had defense lawyers that are making arguments, talking to the prosecutors before the charges come down. There's lots of cases where we as criminal defense lawyers, or when I was prosecutor, we would talk to defense lawyers, let them present some kind of case. So you don't have to prove it at that point as a defense lawyer beyond a reasonable doubt or as a fact, like you said. You just got to prove it enough to make this prosecutor know you don't want to bring this case. And a lot of times that happens. I think the obvious thing that's different between these two cases is the political and outside pressures that were on the Kyle Rittenhouse case. So there are decisions. I was never a chief prosecutor or a division chief or anything like that. Yes. So I was never like the ultimate decision maker. So I'm sure it was similar for you. There were decisions that would go above my head and I had to do what I was told at that point. But if I'm trying this case, if I'm Binger, I'm willing to bet he is a decision maker in that office. Like, you don't just throw some schlub on a case like this.
On a high profile like this, No, Binger was the one making the decisions in this case. And don't forget, he does have a boss, because even I had some cases when I was at the prosecutor's office where I believed that it shouldn't have been bought, right? And it was interesting. One case that I got dismissed, for a full dismissal for, a prosecutor before me worked on it, and they tried to get they tried to go through it, and I was like, well, and then when they gave me the file, I'm like, this is cases, this person is innocent. I just see it. And my boss was like, no, I know. And then I literally had to be the defense and say, listen, I don't think this is just. And we brought it all the way to the point. And then eventually I was able to prove to my boss, we should dismiss this case in the interest of justice. And she did it. So, and it's cool because sometimes, but that's the job of a prosecutor. Sometimes people are just dialed in. And people believe that, but, you have to advocate because that's what you're there for. You're not advocating for convictions. It's sexy, right? To say, I got a 99% conviction rate. I only, lock people up. It's very sexy, but it's the hardest thing to do is to tell your boss, hey, this person I think is innocent and we don't have a case. We should let this person go.
Yeah, no, I agree with you. And guess what? If you do the right thing like that, your conviction rate will be higher because you're only bringing the real cases and the good cases that are necessary to go to trial. So I think that's an interesting thing. A lot of people don't understand how it goes through all these processes before charges get filed. It's not like a prosecutor sees some video on a phone and they're like, okay, I'm going to charge that guy with a crime. There's a lot that goes through with it, what you're going to charge them with, the Arbery case and all the different charges and the lessers that they charge all of them with. And as co-conspirators, not co-conspirators, but as parties to the murder and accessories to the murder, I think was really interesting. And, to me, that's a really interesting part of the process that we get to explain to people on YouTube that they may not understand because they've never been through it. and lawyers that have been
That's
through
true.
it, there's a lot of different steps to it that I like. So I do want to finish with this question, which I think is the ultimate question everybody wants to know from Chuck Charles. Nate, Mets or Yankees?
I'm a Mets fan. I'm been a lifelong Mets fan, even though
I'm sorry to
Mets is
hear
my
that.
entire team sucks. But yeah. It's easy to be a Yankees fan now. It's
I
so
would assume
easy
it's
to
more
be a
fun.
Yankees
I don't
fan.
know, but I assume it's more fun
That's
to be
true.
a
Yeah.
Yankees fan. Well, Nate, thanks so
But you know
much,
what?
man, for coming on. This was a lot of fun, dude. This was a lot.
Thank you for having me, and thanks for being so nice, chat. I usually have some trolls. I feel bad because my trolls didn't show up and yell at me in the chat.
Good.
I feel, and I gotta go look. I gotta go search for them now. But yeah, no,
Yeah, you got to go
this is
find
great,
them.
man.
Yeah, it was a lot of fun.
And I
So
gotta
everybody appreciate you coming on. Go ahead. What?
no, see, I gotta have you on my channel too, so so we can hash some stuff out. But no, this is fantastic,
I would love
bro.
to.
I really appreciate
I
it.
would love to. All right, everybody, that's it for us today. Thanks for listening.